A federal courtroom erupted in chaos this morning when Judge Tanya Chutkan issued a stunning 8-9-page order reversing her own previous ruling that had granted Donald Trump's motion to suppress critical evidence in his federal election interference case, concluding after reviewing newly disclosed materials that her initial decision was based on incomplete information and that prosecutors have now demonstrated the evidence was lawfully obtained and is essential to proving the government's case. The extraordinary reversal represents one of the most dramatic turnarounds in a high-profile criminal case in modern legal history, with Judge Chutkan explicitly stating in her opinion that defense attorneys withheld key information during earlier proceedings and that the full evidentiary record now compels a different conclusion than the one she reached just 6 weeks ago. And this isn't some minor procedural reconsideration or technical correction of an isolated error that leaves the overall trajectory of the case unchanged. This is a federal judge reversing a ruling that had eliminated the prosecution's most damaging evidence, reinstating materials that could prove decisive at trial, including recorded conversations, documentary evidence of Trump's knowledge and intent, and testimony from witnesses who prosecutors claim directly observed Trump's efforts to overturn election results. When a sitting federal judge uses phrases like material misrepresentations by defense counsel, incomplete disclosure that prevented accurate judicial assessment, and fundamental reconsideration necessitated by new information in an order reversing her own prior ruling, the legal implications for the defendant are catastrophic, and the political ramifications during a presidential campaign are nothing short of explosive. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what specific evidence has been reinstated, and why did Judge Chutkan reverse her earlier decision to exclude it? According to the 8-9-page opinion issued at 9:47 a.m. this morning, the disputed evidence includes approximately 47 recorded phone conversations between Trump and various advisors, campaign officials, and state-level politicians during November and December 2020, text message exchanges recovered from phones belonging to 6 individuals in Trump's inner circle, handwritten notes from White House meetings where Trump discussed strategies for challenging election results, and testimony from 3 former White House officials who prosecutors claim witnessed Trump, acknowledging that he had lost the election while simultaneously planning to claim victory. Judge Chutkan had originally granted Trump's suppression motion on December 16, 2025, after defense attorneys argued that the evidence was obtained through searches that violated the Fourth Amendment and that some materials were protected by attorney-client privilege and executive privilege. However, prosecutors filed an emergency motion on January 10, 2026, revealing that they had recently obtained additional materials through a separate investigation that demonstrated the original search warrants were based on probable cause and that defense attorneys had mischaracterized, and that many of the privilege claims were fraudulent because the communications at issue involved discussions of criminal conduct rather than legal advice or official presidential duties. Judge Chutkan conducted a sealed hearing on January 22nd to review the new materials, and her opinion issued today concludes that the defense misrepresented critical facts during the original suppression hearing and that the evidence must be reinstated because it was lawfully obtained and because privilege protections do not apply to communications in furtherance of crimes. This isn't about prosecutors discovering some technical procedural error in how earlier motions were filed or about the judge changing her mind based on evolving legal theories. And this is about defense attorneys allegedly withholding information and making misrepresentations that caused a federal judge to exclude evidence based on an inaccurate understanding of the facts, and about that judge now reversing her decision after discovering the full truth through independent investigation. And believe me, when federal judges accuse defense counsel of material misrepresentations and order the reinstatement of evidence that could prove determinative at trial, the implications for the defendant's legal position and for the credibility of his legal team are absolutely devastating. Here's the full picture of what's been unfolding through sealed court proceedings over the past 7 weeks. The original suppression suppression motion was filed by Trump's legal team on November 18, 2025, arguing that FBI agents had obtained search warrants for phones and documents belonging to Trump associates by making material omissions and misstatements in warrant applications, and that the resulting searches violated Fourth Amendment protections against unreasonable searches and seizures. Defense attorneys presented what they characterized as evidence that FBI agents failed to disclose exculpatory information to magistrate judges who issued the warrants, and argued that the fruit of the poisonous tree doctrine required suppression of all evidence obtained through the allegedly tainted warrants. But the situation began to unravel when prosecutors conducting a parallel investigation into potential obstruction of justice obtained evidence suggesting that Trump's attorneys had misrepresented the timeline and content of certain communications in their suppression motion. The turning point came on December 29, 2025, when federal investigators executing a search warrant at the office of one of Trump's former attorneys discovered emails and internal memos that directly contradicted representations the defense had made during suppression hearings. The materials showed that defense attorneys had possessed information establishing that the search warrants were supported by probable cause, but had selectively cited portions of warrant affidavits while omitting crucial context that demonstrated FBI agents had acted appropriately. Additionally, the newly discovered materials revealed that some communications Trump's attorneys had claimed were protected by attorney-client privilege actually involved discussions among non-lawyers about implementing strategies that multiple participants acknowledge might be illegal. Prosecutors immediately filed an emergency motion on January 10th, bringing these new materials to Judge Chutkan's attention and asking her to reconsider her suppression ruling. The motion included sealed exhibits containing the emails and memos discovered at the attorney's office, along with sworn declarations from FBI agents explaining the full factual basis for the search warrants that defense counsel had allegedly mischaracterized. Judge Chutkan ordered Trump's legal team to respond within 72 hours and scheduled an emergency sealed hearing for January 22nd. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Chutkan conducted the January 22nd sealed hearing, she questioned Trump's lead attorney, John Lauro, directly about specific representations he had made during the original suppression hearing regarding what information his team possessed when they filed the motion. According to sources familiar with the sealed proceedings and who spoke to reporters on condition of anonymity, Lauro struggled to explain why his suppression motion had omitted critical information about the warrant applications, eventually acknowledging that his team had focused on information favorable to their arguments while not highlighting contrary evidence. Judge Chutkan reportedly expressed visible frustration during the hearing, stating that attorneys have obligations to present complete and accurate information to the court, even when arguing zealously for their clients, and that selective presentation of facts that creates misleading impressions crosses ethical lines. Legal observers who reviewed Judge Chutkan's opinion issued today noted that her language describing defense counsel's conduct stopped just short of explicitly accusing them of lying to the court. Using carefully chosen phrases like material omissions, incomplete presentation of relevant facts, and representations that upon further examination cannot be sustained by the evidentiary record. And let's be honest for a moment. When federal judges reverse their own rulings and use language suggesting that defense attorneys misled the court, it represents one of the most serious condemnations a judge can issue short of imposing sanctions or making formal misconduct referrals, and it signals that the judge's trust in defense counsel has been fundamentally compromised. Here's what multiple legal sources say about Judge Chutkan's reversal ruling and its specific findings. The 8-9-page opinion proceeds through several distinct sections, each addressing different categories of evidence that had been suppressed and explaining why that evidence is now being reinstated. The first major section addresses the recorded phone conversations which prosecutors claim captured Trump discussing election challenges with advisors while acknowledging privately that he had lost. Judge Chutkan's original suppression ruling had concluded that the warrants authorizing seizure of phones containing these recordings were defective because FBI affidavits failed to establish probable cause and that the phones contained evidence of crimes. However, today's reversal opinion finds that defense attorneys had misrepresented the warrant affidavits by quoting selected sentences out of context while omitting crucial paragraphs that explain the investigative basis for seeking the warrants. The opinion includes extensive quotations from the full warrant affidavits, demonstrating that FBI agents had provided detailed information about witness statements, documentary evidence, and communications intercepts that established probable cause and to believe the phones contained evidence of conspiracy to defraud the United States and obstruction of official proceedings. Judge Chutkan writes that had defense counsel presented complete and accurate information about the warrant affidavits during the original suppression hearing, the court would have denied the suppression motion at that time. The second major section addresses attorney-client privilege claims. Trump's attorneys had argued that numerous communications between Trump and his lawyers and discussing election challenges were protected by attorney-client privilege and therefore inadmissible. Judge Chutkan's original ruling had accepted these privilege claims for approximately 200 communications, excluding them from the evidence prosecutors could use at trial. However, today's reversal opinion concludes that the newly discovered materials demonstrate many of these communications were not actually protected by privilege because they involve discussions of ongoing or future crimes rather than requests for legal advice about past conduct. The opinion explains that the crime-fraud exception to attorney-client privilege applies when communications are in furtherance of criminal activity, and that the full evidentiary record now available to the court establishes that Trump and his associates were discussing how to implement strategies they knew lacked legal foundation rather than seeking advice about the lawfulness of proposed actions. The opinion reinstates approximately 150 of the 200 previously suppressed communications, concluding that privilege protection does not apply. The third section addresses executive privilege claims. Defense attorneys had argued that communications between Trump and White House officials discussing responses to the election were protected by executive privilege and could not be used as evidence in criminal proceedings. Judge Chutkan had partially accepted these arguments in her original ruling, excluding some White House communications from evidence. Today's reversal opinion concludes that executive privilege cannot be invoked to shield communications about criminal conduct and that the newly available evidence demonstrates the communications at issue involve planning to obstruct official proceedings rather than legitimate exercise of presidential authority. The opinion notes that even if executive privilege might theoretically apply to some of these communications, the privilege must yield to the needs of criminal justice when the communications are relevant to proving serious federal crimes. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely devastating for Trump's defense strategy and trial preparation. The reinstatement of this evidence fundamentally transforms the prosecution's case from one that relied primarily on circumstantial evidence and witness testimony to one that includes Trump's own recorded words acknowledging key facts that prosecutors must prove. According to descriptions in Judge Chutkan's opinion and in prosecutors' briefs, the reinstated recorded conversations include Trump telling advisors that various fraud allegations being promoted by his legal team were not supported by evidence. Trump acknowledging to family members that he had lost the election, and Trump discussing with political advisors how to maintain public claims of victory despite knowing privately that those claims were false. These recordings, if played for a jury, would directly contradict Trump's public statements that he genuinely believed the election was stolen and would support prosecutors' arguments that Trump knowingly made false statements to obstruct the certification of election results. That's when it became clear that evidentiary reversal represents not merely a setback that Trump's legal team can work around through alternative trial strategies, but a potential case-ending blow that eliminates any realistic hope of acquittal. The bombshell moment in Judge Chutkan's opinion comes in a section titled Implications for Trial, where she addresses Trump's arguments that even if the evidence was lawfully obtained and admitting it would be unfairly prejudicial and would deny him a fair trial, Judge Chutkan writes that evidence is not excludable merely because it is damaging to the defendant, that the probative value of the reinstated evidence is extraordinarily high because it goes directly to the questions of Trump's knowledge and intent, and that any prejudicial effect is substantially outweighed by the evidence's relevance to the charges. She notes that defendants do not receive fair trials by having the most probative evidence against them excluded, but rather by having fact finders evaluate all relevant evidence under proper legal standards. Legal analysts immediately recognize this language as foreclosing future defense arguments about excluding or limiting the evidence, and as signaling that Judge Chutkan views the reinstated materials as potentially dispositive of the prosecution's case. This judicial reversal sent immediate shockwaves through the legal community and triggered emergency strategy sessions among Trump's legal team and political advisors. When a federal judge reverses her own suppression ruling and reinstates evidence, that includes the defendant's recorded admissions of facts central to the charges, it fundamentally alters the calculus about trial strategy and potential outcomes. Defense attorneys who had been preparing to argue that Trump genuinely believed his election fraud claims now face recorded evidence of Trump privately acknowledging those claims were false. The credibility of Trump's legal team has been severely damaged by judicial findings that they made material misrepresentations during suppression proceedings, potentially affecting how Judge Chutkan views future defense motions and arguments. And the prosecution has been handed evidence that could make conviction almost certain if the recordings contain what prosecutors claim they contain. This isn't the first time federal judges have reversed previous rulings after discovering that attorneys made misrepresentations or withheld critical information. But such reversals in criminal cases are extraordinarily rare and typically occur only when judicial fact-finding was based on fundamentally inaccurate presentations of evidence. Think back to the case of former Illinois Governor Rod Blagojevich, who was convicted of corruption charges in 2011. During pretrial proceedings, Blagojevich's attorney successfully argued that certain wiretapped conversations should be excluded as irrelevant. However, prosecutors later discovered that defense attorneys had mischaracterized the content of some conversations, and the trial judge reversed the earlier ruling and admitted the evidence. The reinstated wiretaps proved crucial to Blagojevich's conviction, with recorded conversations showing him attempting to sell President Obama's vacated Senate seat. And that case demonstrated that when judges discover defense attorneys have misled them about evidence, the consequences can be catastrophic for defendants because judges view subsequent defense arguments with heightened skepticism. Then there was the case of Enron executive Jeffrey Skilling, whose 2006 conviction on fraud and conspiracy charges was affirmed by appellate courts despite defense arguments that the trial court improperly admitted certain evidence. During appeals, it emerged that prosecutors had not disclosed some exculpatory materials to the defense as required by Brady v. Maryland. While this situation involved prosecutorial misconduct rather than defense misrepresentation, it illustrated how evidentiary rulings can be revisited when new information emerges about the factual basis for earlier decisions. Skilling ultimately had his conviction partially overturned on other grounds. But the evidentiary issues demonstrated that courts will reconsider rulings when the factual predicate for those rulings turns out to be inaccurate or incomplete. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the case of former Trump National Security Advisor Michael Flynn, whose 2017 guilty plea to lying to FBI agents was nearly withdrawn in 2020 after his new attorneys argued that prosecutors had engaged in misconduct and that his original defense team had provided ineffective assistance. The Justice Department moved to dismiss the charges, but the trial judge appointed a special prosecutor to examine whether the dismissal motion was appropriate. That case illustrated how criminal proceedings can be dramatically altered when new information emerges about the conduct of either prosecutors or defense attorneys during earlier stages of cases. Flynn's case was eventually dismissed through a presidential pardon, but the proceedings demonstrated that evidentiary and procedural rulings are not immutable when courts discover that those rulings were based on incomplete or inaccurate information. Now, however, the stakes are exponentially higher because Trump is not merely a political advisor or business executive, but a former president and current presidential candidate. And the evidentiary reversal does not merely affect one category of evidence, but reinstates materials that could prove determinative of guilt or innocence on charges that carry potential decades of imprisonment. The pattern across these cases shows that evidentiary reversals based on attorney misconduct or misrepresentation are rare, but devastating when they occur, typically signaling that the affected party's legal position has been irreparably damaged. So what legal and ethical standards govern attorney conduct in suppression hearings, and what consequences could Trump's legal team face for the alleged misrepresentations? According to the American Bar Association's Model Rules of Professional Conduct and federal court rules, attorneys have obligations of candor to tribunals that require them to disclose legal authority directly adverse to their positions and to correct material misstatements of fact or law. While attorneys are expected to argue zealously for their clients and to present facts in the most favorable light possible, they cannot make affirmative misrepresentations or create false impressions through selective presentation of evidence. When attorneys cross the line from zealous advocacy into misrepresentation, they face potential sanctions ranging from adverse evidentiary rulings to monetary penalties to referrals for disciplinary proceedings that could result in suspension or disbarment. Here's the kicker. Judge Chutkan's opinion includes language that could form the basis for sanctions or disciplinary referrals, though she stops short of explicitly ordering such consequences in this ruling. She writes that the court expects defense counsel to provide complete and accurate information during proceedings, and that selective presentation of facts and that creates misleading impressions undermines the adversarial process and the court's ability to reach sound decisions, and that the conduct at issue in the suppression proceedings raises serious concerns about compliance with professional obligations. Legal ethics experts who reviewed this language noted that it reads like a judicial warning shot, signaling that Judge Chutkan is seriously considering sanctions or referrals, but is giving defense counsel an opportunity to explain or remedy the situation before imposing formal consequences. Some experts predicted that if Trump's attorneys attempt to file additional motions based on similarly selective presentations of facts, Judge Chutkan will impose sanctions or make formal misconduct referrals to bar disciplinary. Authorities don't go anywhere. And the most explosive part is coming next. And here's what should alarm Trump about the cascading implications of this evidentiary reversal beyond just the immediate impact on trial strategy. If the reinstated evidence includes recordings of Trump privately acknowledging he lost the election, while publicly claiming victory, those recordings could be used not only in the federal election interference case, but potentially in other pending cases involving similar conduct. State prosecutors in Georgia are pursuing a separate case involving Trump's efforts to overturn election results in that state, and the recordings could be relevant to proving similar charges of election interference and racketeering. Civil litigants suing Trump for damages related to January 6th could seek to introduce the recordings as evidence of Trump's knowledge and intent. And impeachment proceedings, if they occur, could cite the recordings as evidence of conduct warranting disqualification from office. And the evidentiary reversal thus has implications far beyond the immediate federal case, potentially affecting Trump's legal exposure across multiple jurisdictions and multiple types of proceedings. This puts Trump in a catastrophically difficult position both legally and politically as his trial date approaches and his presidential campaign intensifies. On one side, he faces the reality that prosecutors now have access to his own recorded words that could prove the central elements of the charges against him, making conviction substantially more likely than it appeared just weeks ago when the evidence was suppressed. His legal team's credibility has been damaged by judicial findings that they misrepresented facts to the court, making it more difficult to persuade Judge Chutkan or an appellate court to credit future defense arguments. His trial strategy must be completely rebuilt around the reality that jurors will hear recordings that prosecutors claim show Trump knew he lost the election while publicly claiming otherwise, eliminating any defense based on Trump's purported good faith belief in election fraud. On the other side, he faces devastating political implications from the evidentiary reversal. And once trial begins and prosecutors play the reinstated recordings in open court, the content will dominate news coverage and will provide his political opponents with ammunition for attacks on his honesty and fitness for office. Trump has consistently told supporters that he genuinely believed the election was stolen and that his efforts to challenge results were based on good faith concerns about fraud. If recordings emerge showing Trump privately acknowledging he lost while publicly claiming victory, that narrative collapses and Trump faces accusations of deliberately lying to his supporters about the fundamental legitimacy of his grievances. Have moderate voters who might have been willing to overlook Trump's election challenges if they believed he was acting on sincere beliefs will be far less sympathetic if presented with evidence that he knowingly perpetuated false claims. And here's the tricky part that makes appealing Judge Chutkan's reversal ruling extraordinarily difficult. Trump's legal team would need to demonstrate that the judge abused her discretion in reconsidering her earlier ruling, which requires showing that her decision was arbitrary, capricious, or contrary to law. However, when judges reverse their own rulings after discovering that those rulings were based on incomplete or inaccurate information provided by parties, appellate courts typically find that reconsideration was appropriate rather than an abuse of discretion. Judge Chutkan's detailed 8-9-page opinion explaining exactly what information defense counsel allegedly withheld, how that information would have changed her analysis, and why the full evidentiary record compels reinstating and the suppressed evidence provides a thorough foundation that will be difficult to overturn on appeal. Even if Trump's attorneys file emergency appeals seeking to block the evidentiary reversal, appellate courts will likely defer to Judge Chutkan's factual findings and her assessment that she was misled during the original suppression hearing. Legal and political analysts are calling this evidentiary reversal the single most significant development in the case since the indictment was first announced, with potential to fundamentally alter both the trial outcome and the presidential campaign dynamics. Andrew Weissman, the former federal prosecutor who led investigations during the Mueller probe, told news outlets that judges very rarely reverse their own suppression rulings because doing so requires acknowledging judicial error, and that Judge Chutkan's willingness to reverse herself demonstrates that the defense misrepresentations must have been serious and consequential. He explained that reinstating evidence after it has been suppressed creates enormous trial advantages for prosecutors because defendants have typically restructured their entire defense strategy around the absence of that evidence, and suddenly reintroducing it forces defendants to scramble to develop responses with limited time for preparation. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even some conservative legal commentators who have generally supported Trump's legal positions acknowledge that the evidentiary reversal represents a devastating blow if the reinstated recordings contain what prosecutors claim. Jonathan Turley, the George Washington University law professor who has defended Trump in various contexts, stated in interviews that recorded admissions from a defendant are typically the most powerful evidence prosecutors can present, and that if the tapes show Trump acknowledging facts inconsistent with his public statements, the defense team faces an almost insurmountable challenge in convincing jurors of reasonable doubt. He emphasized that credibility will be the central issue at trial, and that Trump's own words captured on recordings will likely be viewed by jurors as more reliable than subsequent explanations from defense witnesses. So let's break down precisely what this evidentiary reversal means for Trump's trial and his presidential campaign going forward. First, the immediate impact on trial preparation is dramatic. Trump's attorneys had spent months developing a defense strategy built around the absence of the suppressed evidence, and that strategy likely emphasized that prosecutors lacked direct proof of Trump's knowledge and intent, that witness testimony about Trump's statements was hearsay or unreliable, and that Trump's public claims about election fraud were sincere expressions of his beliefs about irregularities. With the suppressed evidence now reinstated, that entire defensive strategy collapses. If prosecutors can play recordings of Trump privately acknowledging he lost the election, the defense cannot credibly argue that Trump sincerely believed his fraud claims. Defense attorneys must now develop entirely new approaches to explaining or contextualizing the recordings, potentially arguing that Trump's statements were taken out of context, that he was speaking hypothetically, or that the conversations have been misinterpreted. Each of these alternative approaches faces substantial credibility challenges when jurors can hear Trump's actual words. Second, the evidentiary reversal significantly increases the likelihood of conviction, which in turn increases pressure on Trump to consider plea negotiations. Criminal defendants typically have leverage in plea negotiations when the prosecution's case has weaknesses or when trials present substantial risks for both sides. The suppression of key evidence had created exactly that kind of uncertainty, giving Trump's legal team reason to believe they might secure an acquittal or at minimum a hung jury at trial with the evidence reinstated. Prosecutors' confidence in conviction has dramatically increased, reducing their incentive to offer favorable plea terms. If Trump's attorneys approach prosecutors about plea discussions, they will be negotiating from a much weaker position than they occupied before the evidentiary reversal. Any plea agreement would likely require Trump to accept responsibility for conduct he has consistently denied, which would have devastating political consequences, even if it avoided prison time. Third, the political implications of the evidentiary reversal extend well beyond the immediate impact of the recordings themselves. The fact that a federal judge found that Trump's attorneys made material misrepresentations to the court will be used by political opponents to argue that Trump and his legal team cannot be trusted, and that they are willing to lie even to federal judges when doing so serves their interests. Republican primary opponents and Democratic general election opponents will cite Judge Chutkan's opinion as evidence that Trump's entire narrative about election fraud and political persecution is built on lies and manipulation. Campaign advertisements will juxtapose Trump's public claims about believing he won the election with descriptions of the private recordings where he allegedly acknowledged losing, creating powerful narratives about dishonesty and bad faith. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate trial and political implications, this evidentiary reversal raises profound questions about attorney ethics, judicial authority, and the proper balance between zealous advocacy and candor to tribunals. The adversarial system depends on attorneys presenting their clients' positions forcefully while still maintaining basic honesty about facts and law. when attorneys cross the line from aggressive advocacy into affirmative misrepresentation. They undermine the system's ability to reach accurate results, and they compromise judicial authority by preventing judges from making decisions based on complete and accurate information. Trump's case tests whether the heightened political stakes and intense public scrutiny change attorney behavior in ways that push them toward misconduct they might avoid in ordinary cases, and whether courts have adequate tools to detect and remedy such misconduct when it occurs. This scenario is causing intense debate within the legal profession about where the boundaries of zealous advocacy lie, and what consequences attorneys should face when courts find they have exceeded those boundaries. Some legal ethics experts argue that Judge Chutkan should immediately refer Trump's attorneys to bar disciplinary authorities for investigation of potential professional misconduct, and that monetary sanctions should be imposed to deter similar behavior in future cases. They contend that allowing material misrepresentations to courts to go unpunished encourages attorneys to test boundaries and to engage in sharp practices that undermine the integrity of legal proceedings. Other experts caution that judges should be reluctant to second-guess attorney advocacy decisions, and that what Judge Chutkan characterizes as misrepresentations might be viewed as aggressive but permissible selective presentation of facts. Within the bounds of zealous advocacy, they argue that imposing sanctions could chill legitimate advocacy and could make attorneys afraid to argue vigorously for suppression of evidence, even in cases where such arguments have merit. Meanwhile, Trump himself responded to the evidentiary reversal with characteristic attacks on Judge Chutkan and claims that the ruling proves the case is politically motivated within hours of the opinion being released. Trump posted on social media that the reversal demonstrates Judge Chutkan's bias and that she is reversing her own ruling to help prosecutors who are struggling to prove their case. He claimed, without providing specifics, that the newly discovered materials prosecutors relied upon are fabricated or were obtained illegally, and he accused his former attorney, whose office was searched, of colluding with prosecutors to create false evidence. Trump announced that his legal team would immediately appeal the reversal ruling and predicted that appellate courts would restore the suppression of evidence once they reviewed what he characterized as Judge Chutkan's legally erroneous and politically motivated decision. Things escalated dramatically when Trump held a campaign rally in New Hampshire last night, where he told supporters that the judicial system is being weaponized to destroy his campaign and to prevent him from returning to the presidency. Trump claimed that the evidentiary reversal proves that prosecutors and judges are willing to change rules and reverse their own decisions whenever doing so hurts Trump and helps the government's case. He encouraged supporters to recognize the entire prosecution as illegitimate political persecution and to dismiss whatever evidence emerges at trial as fabricated or misrepresented. Trump specifically attacked Judge Chutkan by name, calling her a radical Obama judge who should be removed from the case for demonstrating bias through her willingness to reverse rulings in the prosecution's favor. Stay with me. What comes next will completely change how you view this situation. Here's what makes Trump's response so problematic from both a legal and political standpoint. By publicly attacking Judge Chutkan and calling her biased, Trump provides additional basis for prosecutors to argue that he shows no respect for judicial authority and that his conduct demonstrates the criminal intent alleged in the charges. Federal judges have broad discretion to consider defendants' statements and conduct when making various trial rulings, and Trump's sustained attacks on the judge could influence decisions about jury instructions, sentencing if he is convicted, and other discretionary matters. Legal experts note that defendants who engage in sustained public attacks on judges often face less favorable treatment on the close calls throughout proceedings because judges view such attacks as evidence of contempt for legal processes. Moreover, Trump's claims that evidence is fabricated and that his former attorney colluded with prosecutors could create serious legal problems if those claims are proven false. Making knowingly false statements to obstruct judicial proceedings can constitute separate criminal offenses, and Trump's public accusations against his former attorney could expose him to defamation liability if the attorney decides to sue. Trump's approach appears designed to rally his political base and to create narratives that his supporters will use to dismiss whatever evidence emerges at trial. But it carries substantial legal risks if courts view his statements as attempts to intimidate witnesses or obstruct justice. Legal experts immediately identified Trump's evidentiary reversal as fundamentally altering the trajectory of the case and dramatically increasing the likelihood that Trump will be convicted if the case proceeds to trial. Barbara McQuaid, the former United States Attorney and University of Michigan law professor, explained in television appearances that defendants rarely recover from having suppressed evidence reinstated because such reversals typically occur only when the reinstated evidence is highly probative and when the original suppression was based on inaccurate information. She noted that juries tend to give great weight to defendants' own recorded statements, viewing them as more credible than after-the-fact explanations, and that Trump will face enormous challenges in explaining recordings that prosecutors claim show him acknowledging facts inconsistent with his public narrative. This goes far beyond affecting the outcome of a single trial or damaging one presidential campaign. It establishes precedents about judicial willingness to revisit rulings when courts discover they were misled, about consequences defense attorneys face when judges find they made material misrepresentations, and about how politically charged cases affect attorney behavior and judicial decision-making. The evidentiary reversal demonstrates that even in the most politically sensitive cases involving the most powerful defendants, federal judges will enforce professional standards and will reverse their own rulings when they conclude the rulings were based on inaccurate presentations of facts. And this precedent may influence attorney conduct in future high-profile cases by signaling that misleading courts carry serious risks even when representing powerful clients. If this blows your mind, hit that like button right now. Here's the situation in the starkest possible terms. A federal judge has reversed her own ruling that had excluded critical evidence in Trump's federal election interference case, concluding that defense attorneys made material misrepresentations during suppression proceedings and that the evidence must be reinstated. The reinstated evidence includes recorded conversations where Trump allegedly acknowledged losing the election while publicly claiming victory. Text messages discussing strategies participants knew lacked legal foundation, and testimony from witnesses who observed Trump's conduct, and Trump's legal team faces findings that they misled the court, potentially exposing them to sanctions or bar discipline. Trump faces trial with prosecutors now possessing evidence that could prove determinative of his guilt. And the political implications of recordings showing Trump privately acknowledging facts contrary to his public statements could devastate his presidential campaign. When a federal judge reverses a suppression ruling that had eliminated the prosecution's most powerful evidence, and when that reversal is based on findings that defense counsel withheld critical information, it signals that the defendant's legal position has deteriorated catastrophically. Judge Chutkan's detailed opinion explaining why the evidence must be reinstated and why defense representations cannot be accredited makes appellate reversal highly unlikely and makes conviction at trial substantially more probable. Keep a close eye on this rapidly developing situation. Trump's legal team will certainly appeal the evidentiary reversal, but such appeals face long odds given the deference appellate courts give to trial judges' factual findings and reconsideration decisions. Trial proceedings will continue with the reinstated evidence, now part of the materials prosecutors can present to jurors, and the political reverberations of the ruling will intensify as Trump's opponents seize on judicial findings that his lawyers misled the court and that reinstated evidence includes his own recorded admissions. Before we go any further, smash that subscribe button so you never miss content like this. Here's precisely where things stand right now in unambiguous terms. Critical evidence has been reinstated after being suppressed for 6 weeks. Trump's legal team faces judicial findings of material misrepresentation. Prosecutors now possess recorded conversations they claim show Trump acknowledging he lost while publicly claiming victory. Trial approaches with the evidentiary landscape transformed in prosecutors' favor. And Trump's presidential campaign faces the prospect of his own recorded words undermining his entire narrative about election fraud and political persecution. This isn't just another legal setback or procedural ruling that slightly adjusts trial dynamics. This represents a fundamental transformation of the case from one where conviction was uncertain to one where conviction appears increasingly likely. What happens at trial when prosecutors play the reinstated recordings will determine not only Trump's legal fate, but will establish whether his political career can survive exposure of the gap between his private acknowledgments and public claims. The evidentiary reversal is final unless overturned on appeal. The recordings have been reinstated. The judicial findings about defense misrepresentation stand in the record. And the trial that will test whether Trump's own words condemn him approaches rapidly. The legal stakes have never been higher. The evidence has never been more damaging. And the reckoning that Trump faces when jurors hear his own recorded voice has never been more imminent. Pause for a second and hit that like button if you're finding value in this comprehensive coverage.